At 4:47 yesterday afternoon, something unusual happened inside Donald Trump's legal operation. There was no statement, no immediate counterattack, no familiar media blitz, just silence. But this was not the calculated silence of attorneys carefully drafting a response. It was the paralysis of a team that had just realized the ground beneath them was gone. 18 hours earlier, while most of the country slept, the Supreme Court of the United States issued a ruling that fundamentally altered Trump's legal reality, not by rejecting a single argument, but by dismantling an entire defensive structure that had been built over the past 3 years. Every claim of absolute immunity, every assertion of executive privilege, every delay strategy deployed across multiple criminal and civil cases, all of it collapsed in one decision. In 247 years of American constitutional history, no former president has ever been stripped of legal protections this comprehensively. Not Richard Nixon, not Bill Clinton. There is no modern precedent for what just occurred. What makes this ruling especially consequential is not only its substance, but the unanimity behind it. All 9 Supreme Court justices voted in the same direction. That includes the 3 justices appointed by Donald Trump himself, the very judges widely viewed as his final line of defense. The assumption for years had been that at minimum those appointments would produce a divided court. They did not. There was no dissent, no carve-out, no legal escape hatch left behind. This ruling does not merely resolve a specific case. It establishes a broader principle. A former president is not shielded from criminal accountability when alleged conduct falls outside lawful official duties. From that moment forward, the clock began ticking. Within 14 days, Donald Trump must submit a formal response to a legal demand that even seasoned constitutional attorneys acknowledge is extraordinarily difficult to meet without creating additional exposure. This is no longer a political story. It is a test of the outer limits of presidential power and whether the American legal system functions when confronted with its most extreme challenge. What happens next will not be decided by cable news debates or campaign rhetoric. It will be decided in courtrooms, on filing deadlines, and under oath. And for the first time, the question is no longer whether the walls are closing in. It is whether there is anywhere left to stand. To understand why this Supreme Court ruling matters so much, you have to understand what did not happen in American history. The United States has faced presidential scandals before. It has faced constitutional crises, but it has never faced a moment where the court removed so many legal defenses from a former president. At the same time, Richard Nixon resigned under the shadow of impeachment, but he was never criminally charged. The system avoided that test entirely when President Gerald Ford issued a blanket pardon. Bill Clinton was impeached, but his conduct was narrowly confined to perjury in a civil matter. The Supreme Court never ruled that a former president could be broadly exposed to criminal liability for actions taken while in office until now. What makes this ruling unprecedented is not simply that Trump lost. Presidents lose cases all the time. What makes it historic is that the court did not limit its decision to a narrow procedural question or a single statute. Instead, it addressed the underlying theory Trump has relied on across nearly every legal front. The idea that the presidency itself confers a permanent shield. That theory is now gone. The court's opinion makes clear that there is no constitutional doctrine that places a former president beyond the reach of criminal law when the conduct alleged is personal, unlawful, or undertaken in pursuit of private ends. That language matters. It draws a bright line where ambiguity once existed. Official authority ends where criminal conduct begins. This is a structural shift, not a case-specific ruling. For decades, courts avoided answering this question directly. They deferred. They assumed future restraint. They relied on norms rather than rules. This decision abandons that approach. It replaces assumption with doctrine. And once doctrine is established at the Supreme Court level, it does not easily disappear. Another reason this ruling stands apart is its scope. It does not distinguish between federal and state exposure in any meaningful way. The immunity analysis applies across jurisdictions. That means defenses Trump intended to deploy in multiple courts vanish simultaneously. One ruling, many consequences. Most importantly, the court did not write this opinion as if it were dealing with a unique individual. It wrote it as if it were closing a loophole in the constitutional system itself. The language is forward-looking. It is designed to prevent any future president from attempting the same strategy. That is why legal scholars are calling this the most consequential ruling on presidential accountability in generations. It does not punish a man. It redraws the boundaries of the office. And once boundaries are redrawn at that level, there is no appeal beyond them. If this ruling had split along ideological lines, it it would still have been historic. A narrow decision 5-4 would have allowed both sides to claim validation. Supporters would call it accountability. Critics would call it partisanship. The country would argue about motives rather than consequences. That is not what happened. The Supreme Court ruled unanimously, 9 votes to 0. No dissent, no concurring opinion carving out exceptions, no justice, signaling discomfort with the outcome. And that fact alone changes how this decision must be understood. 3 of the justices on that bench were appointed by Donald Trump himself. They were selected precisely because of their views on executive power, judicial restraint, and skepticism toward expansive criminal liability. For years, Trump's legal strategy assumed those appointments represented an institutional backstop, a firewall, a margin of safety. That assumption collapsed. When justices who share a broad conservative judicial philosophy decline to defend presidential immunity, it signals something deeper than politics. It signals that the legal arguments themselves failed under scrutiny, not narrowly, completely. This is where context matters. The court did not simply reject a defense. It rejected the premise that the presidency can be used as a permanent refuge from accountability. That is a position conservative jurisprudence has traditionally resisted endorsing, not embraced dismantling. The fact that it did so unanimously indicates that the evidence and legal framework presented left no viable alternative. Unanimity at the Supreme Court is rare in cases of this magnitude. When it occurs, it is often deliberate. It is a signal to lower courts, to prosecutors, and to the public that the issue is settled, that there is no legitimate legal ambiguity left to exploit. This ruling was written to close doors, not open debates. Equally important is what the court did not do. It did not delay. It did not remand the issue for further factual development. It did not invite future reconsideration. The opinion is final in tone and comprehensive in scope. That is not accidental. It reflects an understanding that uncertainty itself had become a risk to the system. By resolving the question of presidential immunity in this way, the court removed a destabilizing variable from every pending case involving Trump. Lower courts now have clear instructions. Prosecutors now have firm ground. Delay tactics rooted in constitutional ambiguity no longer function. For Trump, this means the loss of more than legal arguments. It means the loss of time, the loss of leverage, the loss of the assumption that institutional hesitation would eventually intervene on his behalf. And for the country, it means something broader. The court has drawn a line and chosen clarity over caution. Whether that decision calms the system or accelerates conflict depends on what comes next, because once a line like this is drawn, it cannot be erased. It can only be tested. This moment did not arrive suddenly. It was not the result of a single bad ruling or an unexpected legal ambush. It was the product of a series of decisions that appeared strategic at the time, but in hindsight formed a narrowing corridor with no exit. The first and most consequential mistake was the overreliance on absolute immunity. When the federal appeals court rejected Trump's immunity claim in early 2024, his legal team faced a choice. They could accept the loss, preserve credibility, and pivot to conventional criminal defenses. Instead, they escalated. They took the claim to the Supreme Court, assuming that delay alone would serve as protection. That assumption proved fatal. By forcing the Supreme Court to confront the immunity question directly, Trump's lawyers invited a definitive answer. And once the court decided to answer it, it did so not narrowly, but comprehensively. What might have remained an unresolved gray area became settled law. The very argument designed to shield Trump instead eliminated the shield entirely. The second mistake involved witnesses. Trump's legal strategy consistently relied on the belief that key insiders would remain silent, invoke privilege, or lack documentary corroboration. That calculation underestimated the modern prosecutorial environment. Cooperation agreements, contemporaneous notes, digital records, timelines reconstructed with precision. Once immunity and executive privilege collapsed, those witnesses were no longer peripheral risks. They became central liabilities. Conversations once assumed untouchable became admissible. Statements once protected by custom became evidence. The third mistake was treating the cases as isolated battles rather than interconnected fronts. Trump's team focused heavily on the federal prosecutions, particularly in Washington. Less attention was paid to state-level exposure, especially in Georgia. That separation no longer exists by clarifying that presidential immunity does not insulate a former president from criminal accountability across jurisdictions. The Supreme Court effectively synchronized the cases. A defense weakened in one court, weakened everywhere. There is no longer a federal, state firewall to hide behind. The fourth error was underestimating the civil consequences. Criminal cases dominated the headlines, but civil judgments continued to accumulate in parallel. Appeals were premised in part on the same theories of immunity and privilege. When those theories collapsed, so did the delay. Civil enforcement does not wait for political cycles. It moves on timelines governed by court orders and financial reality. Asset seizures, liens, and judgments operate independently of electoral outcomes. Finally, there was a failure to anticipate compounding exposure. Each case generates evidence. Each ruling influences another court's posture. Each sworn statement narrows future options. This is not a sequence of trials. It is a cascade. Once that cascade begins, control becomes an illusion. What Trump's legal team built was not a fortress, it was a stack. And once the bottom layers gave way, everything above them followed. This is the point where strategy ends and consequence takes over. What makes this moment uniquely dangerous for Donald Trump is not any single case. It is the convergence. Multiple legal tracks, once staggered and compartmentalized, are now moving in parallel. And each one amplifies the pressure on the others. Start with the criminal prosecutions. With immunity arguments eliminated, courts are no longer obligated to pause proceedings while constitutional questions are resolved. Trial schedules that were frozen now move forward. Judges regain discretion. Prosecutors regain momentum. Time, which had been Trump's most reliable ally, becomes his primary enemy. But the criminal cases do not exist in isolation. Civil judgments, long treated as secondary concerns, now accelerate simultaneously. Appeals that relied on executive privilege or immunity lose their foundation. Enforcement mechanisms activate. Unlike criminal trials, civil enforcement does not depend on jury verdicts or lengthy deliberations. It depends on deadlines, compliance, and court authority. Financial exposure compounds quickly. Large judgments trigger asset reviews. Asset reviews trigger seizures. Seizures trigger liquidity crises. Legal defense becomes more expensive precisely as resources become more constrained. That feedback loop is unforgiving. At the same time, evidentiary overlap creates a cascading problem. Testimony given under oath in one case becomes discoverable in others. Documents produced for one court can be subpoenaed by another. Statements made to avoid liability in one jurisdiction can create exposure elsewhere. There is no clean firewall between proceedings. This is how legal pressure becomes systemic. The political consequences follow closely behind. Campaign messaging becomes constrained by legal reality. Statements made on the trail carry legal risk. Fundraising faces donor hesitation. Allies reassess. Loyalty when association carries cost. Silence replaces defense. Distance replaces enthusiasm. This is not a matter of optics. It is a matter of bandwidth. A campaign requires focus, narrative control, and forward momentum. A defendant facing simultaneous criminal, civil, and financial proceedings operates in reaction mode. Every move is defensive. Every statement is vetted. Every appearance carries risk. What emerges is a strategic contradiction. To fight politically, Trump must speak freely. To survive legally, he must speak carefully. Those imperatives are incompatible. Most importantly, each legal loss reshapes the environment for the next proceeding. Judges read prior rulings. Prosecutors cite earlier findings. Juries are drawn from a public already exposed to sworn testimony and judicial conclusions. Momentum becomes a factor. This is why legal analysts describe the current situation not as multiple challenges, but as a convergence point. Once reached, outcomes become harder to isolate and easier to predict. There is no single lever left to pull, no delay that resolves all fronts, no victory in one arena that neutralizes the others. At this stage, the system is no longer reacting to Trump, it is moving around him. As the legal timelines accelerate, the question is no longer confined to Donald Trump's personal fate. What unfolds over the next 90 days will shape how power, accountability, and legitimacy function in the United States going forward. There are three broad paths this moment can take. The first is the path of institutional accountability. Courts proceed, trials move forward, evidence is presented in open proceedings. Witnesses testify under oath. Juries deliberate based on facts rather than affiliation. If the evidence proves guilt beyond a reasonable doubt, convictions follow. If it does not, acquittals result. Either outcome is resolved through established legal process. This path carries short-term costs. Political tension intensifies. Public trust is strained. Protests, rhetoric, and polarization increase. But the long-term effect is stabilizing. The system demonstrates that no office holder is exempt from legal scrutiny. The president is clear and durable. Power remains constrained by law. The second path is institutional failure. Proceedings stall, judges face pressure, witnesses retreat, delays accumulate until momentum dissipates. Cases are dismissed on technical grounds or eroded through attrition. Trump avoids final judgments not because he prevails on the merits, but because the system proves unable to carry the weight of the moment. The consequences here are severe. The message sent is not about Trump alone. It is about incentives. Future leaders learn that maintaining political loyalty and public pressure can override legal accountability. The law becomes conditional. The strongest actors operate under different rules. That erosion does not reverse easily. The third path is fragmentation. Different courts reach different conclusions. State cases proceed while federal cases stall. Some jurisdictions impose consequences, others reject them. Trump becomes legally constrained in some arenas and vindicated in others. The result is not resolution, but contradiction. This outcome is the most destabilizing. Legitimacy fractures along geographic and partisan lines. Legal authority becomes contested rather than accepted. Compliance becomes selective. The rule of law no longer speaks with one voice. History offers examples of all three paths in other democracies. They do not end the same way. The difference lies not in personalities, but in institutional cohesion. What matters most now is not prediction, but process, deadlines, hearings, compliance. The mechanics of law are about to be tested under extreme stress. Courts do not operate on vibes or narratives. They operate on filings, orders, and enforcement. That is why the next phase is critical, not because of what any one person says, but because of what institutions do when delay is no longer an option. The outcome will define more than a case. It will define whether the system still governs power or merely reacts to it. At its core, this moment is not about Donald Trump as an individual. It is about the boundaries of power in a constitutional system that was designed to restrain ambition before it concentrates beyond control. For decades, American democracy relied less on formal enforcement and more on norms. Presidents were expected to self-limit. Institutions assumed good faith. The law existed, but it was rarely forced to confront the most extreme scenarios. That era is over. What the Supreme Court did was not simply resolve a legal dispute. It clarified a rule that had remained dangerously ambiguous, that no individual, regardless of rank or former office, is categorically immune from criminal accountability. That clarity comes at a cost. It forces the system to act where it once hesitated. The next phase will not be defined by speeches or speculation. It will be defined by compliance, by whether court orders are followed, by whether deadlines are met, by whether testimony is given under oath without obstruction or intimidation. These are not abstract principles. They are mechanical tests of whether the rule of law functions when tested by power. The political consequences will be intense. Narratives will harden. Loyalty will be demanded. Pressure will be applied. But courts do not resolve questions of fact through narrative alignment. They resolve them through evidence and procedure. That distinction matters. If accountability holds, the system proves resilient. If it fails, the precedent set will shape behavior far beyond this case. And if outcomes fragment, legitimacy itself becomes contested terrain. None of these paths are comfortable, but avoidance is no longer an option. What happens next will unfold quickly and quietly, not always on television, but in filings, hearings, and decisions that rarely trend online until their consequences are irreversible. By the time outcomes are obvious, they will already be in motion. This is why attention matters now. Not outrage, not celebration, attention. Because when systems change, they do so incrementally until suddenly they don't. Stay focused on what happens next. The dates, the rulings, the compliance. That is where the real story will be written. And once it is written, it will not be easy to undo.